an exhaustive, all-encompassing list. Now, a couple of points related to dominance. First of all, in terms of dominance, there's typically only one dominant undertaking in the market. Okay, in most markets, and just hang on a minute for the exception. In markets, there can only be one dominant undertaking. You can't really say that you've got two undertakings in the market, they're both powerful, and therefore they're both equally as dominant. In that situation, typically there is no dominance. You have two very strong, powerful undertakings in the market. Typically, neither are dominant. Think, for example, Boeing and Airbus, or at least Boeing prior to the 737 MAX problem. Okay? Two airline companies, both representing around 50% of passenger jet sales, both very strong companies, but neither of which was dominant because the market for aircraft is highly competitive. Okay? So it's more often than not a mistake to say that there's two companies in the market, both are equally as dominant. That said, there can be a situation where you can have two or more companies, undertakings, acting together as if they were one undertaking. Okay? And that is a situation of tacit collusion. It's not actual collusion in the sense of an agreement, but it's a situation where the undertakings represent or recognize that coordinating their behavior without an express agreement is in their best interests. Okay, that is a situation where you can have collective dominance. Okay, we will get to that in a couple of weeks, a specific lecture on tacit collusion. But those situations are quite rare, and for exam situations, rarer still, if you know what I mean. Okay, you won't see it on an exam. I typically go over tacit collusion to explain the market phenomenon, but it's one of these cases where people go, what? And then get all panicky about it, so I never examine it. Okay? But it's important to know. So when you talk about a dominant entity, I would say 99.5% of the time you're talking about one large firm in the market. Okay? The remaining 0.5% are cases of tacit collusion, which really arise in a sort of a merger type situation. The problem arises. Okay? So first of all, one dominant entity in a market. Secondly, dominance itself isn't a problem. It's abuse of dominance. Every firm, every undertaking wants to grow up to become the next dominant entity in the market, right? You start off small and you want to become the next Microsoft, Google, or what have you, or Amazon. Okay? So dominance itself isn't a problem. Okay? And the Article 102 does not prevent firms from growing up to become dominant. It only prevents firms, once dominant, from engaging in certain forms of activity. Okay? So that's key. Okay, now, the forms of activity are abuses. We'll go through the non-exhaustive list and point out what is meant. The first set of abuses, directly or indirectly imposing unfair purchases or selling prices or other unfair trading conditions, tends to be exploitative abuses, charging too much. Okay, and the key in that was one of the abuses alleged in United Brands, remember that banana case? Okay, of unfair pricing, excessive pricing. In other words, United Brands was able to sell bananas in the Irish market less at a reduced cost, or reduced price rather, than they were selling them in the German market. So in effect, they were charging an excessive price, or alleged to be charging an excessive price in Germany, and exploiting the German customers. The second set of abuses are exclusionary abuses, trying to use your dominance to exclude your competitors from the market. Limiting production, limiting markets, or technical development to the prejudice of customers. Now, true, by excluding a competitor, it's also to the prejudice of competitors. But the real harm is suffered by the consumers because of the lack of competition in the market. Okay? EU law is typically focused at the harm to the consumers, not necessarily protecting competitors, though that point is somewhat debatable. So, for instance, and as we will see in the next week or so, the Acaso case involved predatory pricing. We used predatory pricing to exclude competitors. The CSC case, refusal to supply. Hoffman-LaRoche involved loyalty rebates. And McGill alleged IP abuses to exclude competition. Discriminatory abuses, applying dissimilar conditions to equivalent transactions, thereby placing some parties at a competitive disadvantage or placing people at a competitive disadvantage. United Brands, where you had discriminatory pricing.
What's the difference between discriminatory pricing and the excessive pricing?
It's the same, they overlap. Okay, so you're about 30 seconds ahead of me. Okay, these abuses, basically, don't think of the abuses as little sort of pigeonhole boxes, but as examples, and there's a significant overlap in this. Okay. Tying abuses. Again, tying abuses also relate to discriminatory abuses because of dissimilar conditions, but making compliance of the inclusion of contracts, blah, 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 blah. Hilti and Tetra Pak. Leveraging abuses is a set of tying abuses. Again, the list in 102 is not exhaustive. Microsoft cases are a very clear case of leveraging or tying, using a near monopoly in operating systems to get an advantage in server operating systems and media players. Okay. We'll see another form of that in a minute. There are other forms of abuse, retaliatory abuses, which is a species of exclusionary abuse. In other words, retaliating, trying to exclude a competitor from one market because of their conduct in either that market or in other markets. Single abuses against the single market, form of partitioning the market, which can be exclusionary and or exploitative. As we saw last week, the Commission is cracking down on this as part of their digital single market strategy. And these categories are not mutually Exclusive predatory pricing can be both exclusionary and exploitative. Tying abuses, similarly, can be used that predatory pricing is used as a retaliatory mechanism as well. Another form of abuse perhaps is a self-preference abuse. Discriminatory or self-preference abuse. In the StreetMap EU versus Google case in the UK, Google was accused of preferring itself or preferring its own subsidiaries by promoting Google Maps on when a search result would be displayed at the expense of StreetMap. Okay, so that when, for instance, you typed in, I want a map of, let's say, South Manchester, the Google Maps site would appear near the top, and Street Maps would appear in a less prominent position. So people's tendency would then be to click on Google Maps and not Street Maps, and therefore traffic would be diverted away from Street Maps to Google Maps. The UK High Court said no, while you could plausibly make out an abuse, it wasn't made out on these facts. It may have been the case that Street Maps was just a poor quality product in Google Maps. Google Shopping, that's where Google was promoting its own subsidiaries and its own affiliated sites by giving them a prominent position in the right-hand column, as well as in the return searches. The commission in 2017 said Google was preferring itself to its competitors, fined it 2.4 billion euros. That is now under appeal. The appeal was heard 2 weeks ago. And in fact, Google seems to be unlikely to win it. Apparently one of the judges, the Irish judge, said, let me get this straight, what you're actually doing is committing a 102 violation. That doesn't really sound hopeful. The judge says that from the bench. Okay? So that's under appeal. I don't think we'll see a decision for a few months at least. So.
Two questions. I don't see what's actually wrong with preferring your own subsidiaries, because wouldn't you want to use your own yourself if you were able to, rather than going to your competitors?
Yeah, I mean, good point.
Because like if I can use my own subsidiaries, why would I want to give business to my competitors?
Yeah, I mean, that's the controversy.
Mm-hmm.
Is that really a form of abuse? Okay, the commission says yes, a lot of people say no. That's why it's being litigated. Okay, so that's why I have discrimination, self-preference, that's why I have the question mark there. Okay, that might be a form of abuse. It may, the English court felt that, yeah, that possibly could be, but it wasn't made out, so they didn't. So even if it wasn't made out, so they didn't have to make a decision. The commission feels it is an abuse, but Google says no, it's not an abuse. So therefore, that's under appeal.
One more question: would this be considered tying? This wasn't also a couple of years ago. Google was fined like 5 billion euros by the EU, or like when developers wanted to make like these Android products, they had to have like a Google.
Yeah, that's a form of tying. That's another Google case.
Yeah.
There's about 3 different Google cases. Google, I think, has been fined. The sum total of Google fines over the last 3 to 4 years exceeds some of the budgetary contributions of smaller EU member states. Okay, so I think there's about 3 of them on point, with Google Shopping being one of the first. Okay. Now, getting back to this, the theory of harm in that Google Shopping case was what, and that's what the decision says, the first article of the decision. By positioning favorably in Google's general search page, Google's own comparison shopping services that constitute an abuse excluding and our comparison shopping services. Okay, so that is a that's basically the crux of the litigation before the general court right now. It's going to go to the it'll go to the ECJ. There's no doubt about that. For that kind of money, it's going before the ECJ. So we're probably not going to see a final result for at least another 3 years. So the final result won't be on the exam. Okay. Okay. But so and there's so look. Now, what constitutes abuse? Okay. We have a non-exhaustive list. These various ideas in the list overlapping, but generally speaking, the court has given us some indication of what is regarded as abuse. And the first case is United Brands again. It says an abuse is where a dominant undertaking can take opportunities, can use opportunities that arise out of it being dominant, and as a result is able to achieve trading benefits which it not normally would have achieved had there been effective competition. It's because the dominant entity, right? What's the definition of dominance? Do you remember what a definition of dominance is? Do you remember what that is? It was only yesterday. Okay. Dominance. What is dominance? It's the ability to act on the market without regard for competitors, suppliers, and customers. You know, not necessarily all of them, but at least some of them. Okay? So, if you're able to do that, abuse is your use of this ability to get further benefits. Okay. We see similar, okay. In Continental Can is slightly different. Continental Can involved abuse in the context of a merger. And this was before there was a merger regulation. So the commission had to use Article 82, in other words 102, to control mergers. Continental Can also recognized that there's a harm, or abuse can also consist in the harm to market structure, weakening the conditions of competition on the market. Okay. So not just to the trading partners, but also to the market itself, further weakening the competitive conditions. Okay. And then paragraph 26, and I pointed out the key line in that is in red. Abuse occurs if an undertaking in a dominant position strengthens such a position in a way that the degree of dominance reach substantially fetters competition. In other words, it reduces competitive possibilities on the market. Okay. Now, that said, there's a slight shift in commission thinking after Continental Can. Okay? Since Continental Can, and this is a quote from the Jones Suffren and Dunn text, since Continental Can, the story of Article 102 has been predominantly one of action against exclusionary abuses. Okay. What this means is that the Commission's focus after Continental Can has been directed towards prosecuting undertakings, dominant undertakings, which are excluding others from the market. Okay? The key to all of this is in their guidelines. And you should have this, reference to this in your syllabus. It's the communication guidance on the Commission's enforcement priorities in applying Article 82 of the EC Treaty. It's the OJ of 2009, C45, page 7. It's in your syllabus. You'll need to download it and have a look at it, okay? And it's 14 pages, I would read them. Okay, now, the reason why the Commission has shifted, okay, from thinking about exploitative abuses to exclusionary abuses can really be explained as follows. Okay? First of all, there's a measurement issue. Exploitative abuses ultimately come down to the question of the price is too high. Right? Sometimes it's easy to measure that the price is too high. Look at United Brands. You look at the price of bananas in Ireland, compared them with the price of bananas in Germany. It costs United Brand more to get the bananas to Ireland, yet the bananas were cheaper in Ireland than they were in Germany, right? So what does that mean? That's prima facie evidence that the prices in Germany are too high. Okay, but how high, or how, how much? By how much? We don't know. Okay. Secondly, oops, how did I do that? The competition authorities, okay, may not completely understand how markets work, particularly two-sided markets. It should be of particular markets, not all particular markets. Okay? And furthermore, suppose you're faced with an exploitative abuse. The old Continental Can question. The appropriate remedy would be to tell United Brands to drop the price of bananas in Germany, right? But by how much? Okay, if you say drop it by any specified amount, the competition authorities are now become a price regulatory authority, and they simply do not have the expertise to do that. Okay? So, the Commission has turned its focus towards, and we'll see what, other reasons why, towards exclusionary abuses. Now, as a result of this, many American antitrust scholars have remarked the Americans protect competition, you, being the EU, protect competitors by allowing them to not be squeezed out of the market. Whether that's true or not is a question, and it's a separate question from whether that's a fair comment. This arose again in a merger context we'll get to. Now, it's often easier. It's much easier and cleaner for competition authorities to prosecute and protect against exclusionary abuses. And the effect on consumers, at least in the competition authorities' minds, will be the same. Okay? Yes?
Yes. So what's the difference in America compared to the EU?
Well, as we will see when we get to the Americans, since about the early part, middle part, the early mid 70s, have been very reluctant to interfere in cases of monopolies. Okay? And to not be worried about monopolists on the market. Okay? And a lot of that, the reason for that comes out of Robert Bork's work. He was an influential antitrust professor at Yale, and then became a judge, federal appellate court judge in the U.S. He was nominated for a Supreme Court seat by Reagan. He didn't get it. Became rather annoyed at the situation and resigned from the judiciary and went back into academia. Okay? His book, The Antitrust Paradox, is significant, it's influential, and it points out that it really regards, there's nothing, doesn't seem to be much of a problem with monopolies. And doesn't think that monopolies could be regulated because by regulation in the way, say, the Europeans would do it, that could, how should we say, raise problems raise a different set of competitive problems, which he regarded to be more harmful to consumers. So basically, the U.S. position is if there's a monopolist in the market, antitrust law really doesn't interfere. Okay, whereas in Europe, obviously, it interferes a lot more. Okay, and we'll see it's very difficult to maintain to sue a monopolist in the U.S. for an antitrust violation. Okay. Now, the Commission's thinking about why it should go after exclusionary abuses and not exploitative abuses can be summarized or can be put as follows. First of all, exploitative abuses result in super competitive returns. That is to say, larger than normal profits. Right? Because of the exploitation involved. In a competitive market, in other words, a market where there are no or very few or limited entry barriers, okay, other firms will enter into the market, okay, and especially when they see the possibility of competing away super competitive returns. Okay, if I see there's great profits to be made over there, I'm likely to enter over there if there are few entry barriers, correct? Okay. Now, it's typically exclusionary conduct tends to throw up these entry barriers. Okay? The dominant undertaking, okay, through its practices is causing some of these entry barriers. So if you remove these barriers to entry, including those barriers that are being thrown up by the dominant undertaking, other firms enter into the market, and with their competitive pressure, they will bring down the high prices. Okay? And to the competition authorities, the Commission, This is a far easier task than monitoring and regulating prices. Okay? But there is a recognition that some form of price regulation may be appropriate when you have a state-owned or a natural monopoly. Water distribution, for instance. Okay. How is the water rate set here? Do you know?
Through the utility company.
Utility, yes, but can the utility companies, they charge you,
Yeah.
but can they charge you, well, they'd like to charge you as much as they want, okay? Okay, you've got a few utility companies, but these utility companies each have a geographic monopoly, right? And the amount that the utility companies can charge for your water is regulated by Ofwat, the Office for Water. Okay? And it's in effect, a price regulation body. It says how much water companies can charge domestic and commercial users of water. Okay. They have apparently, or are alleged to have the specialized knowledge to look at sort of demand, supply, the investment that these companies made, the investment that these companies need to make, look at the books of the companies to see what the returns on capital are, so on and so forth. Okay, so there is some price regulation in certain sectors. Okay, now, finally, even though we'll exclude those sectors where price regulation may be appropriate, focusing on exclusionary abuses requires only an analysis of the practice engaged in by the dominant undertaking. Okay? So you look at what the dominant undertaking is doing at the market, not at the undertaking's books. Okay? And often that data is hard to obtain, even if you're looking at the books proper. Okay, because you can use all sorts of accounting devices to muddle the data. Now, as I said before, the Commission's thinking. Yes.
Yes, I have questions. Can I understand that the dumpings can be understand as the exploitative abuses?
Yeah.
The kind of exploitative abuse.
What?
Dumping.
Dumping is a concept in international trade. Okay, it's not a concept in domestic competition law. Okay, the closest analog you would have to dumping in domestic law would be predatory pricing. Okay. Dumping is an international concept, not a domestic competition law concept. Okay. The Commission's guidance paper. This is important. Have a read through it. You may want to have a look at the background. The background, I guess, in 30 seconds or less. This paper and much of the Commission's thinking arises out of a shift in how the Commission analyzed competition problems after roughly 1999-2000, the turn of the century. What the Commission has done, and is doing, is to take in what they call a more economic approach. That is, look at the economic effects of particular practices to see what these practices or arrangements do on actual markets, as opposed to categorizing certain forms of behavior under some sort of formal rule and judging accordingly. Okay? So the idea is to bring in a greater amount or element of economic analysis and apply that to the specific facts in question to come up with a decision. It arose really out of a number of problems that the commission faced, particularly in merger cases. And they had a very bad year in 1999, where they lost 3 merger cases as a result of what the court said was bad economics. They also got involved in a transatlantic dispute where one merger was prohibited by the commission, even though it was approved by American authorities. The prohibition may have been, or at least it was alleged, certainly by the Americans, on the grounds of bad economics. So as a result, the commission thought it would be appropriate to up its game, so to speak, in terms of economics, and use this. A very good book by Ann Witt on the economic approach to EU competition law. It's in the library if you want to have a look through that. But the key thing here is it's an effects-based approach, okay, that first of all focuses on consumer surplus. Guarding consumer surplus is the underlying principle of this approach to Article 102. And it's also the underlying principle of, as we saw, the Commission's approach to Article 101, right? In the guidance paper on 101.3, right? Remember that? Consumer surplus is to be protected. So, in the paper, we'll focus on those types of conduct that are most harmful to consumers, and then, but it also, there is a recognition of a need to safeguard the competitive process, sort of a recognition that Continental can still applies.
So consumer surplus is their focus for 101 and 102.
Correct.
And all 101, 2, 3, all of that.
All of that, according to the Commission. 101, and you know, look at the see the guidelines on 101.3. So that's the consumers. That's the Commission's focus in 101. Commission's focus on in 102 is on paragraph. What did I say? Paragraph 4, paragraph 5 of the guidance paper. Paragraph 5 of the guidance paper. You'll see it also in merger control.
So protecting the consumers is a priority.
Yeah, consumer surplus is the priority, according to the Commission. Now, of course, this is a real problem. Okay, as I said before, this is a real problem with the treaties. Where in the treaties does it say consumer surplus is a priority? In fact, if you looked at other clauses in the treaties, you'd see that their goals of competition law are subsumed with other goals of the union, right? So, okay. So the focus is on consumer surplus, and it's an effect-based. Okay, you look at the effects of a given practice. Okay, looking for clear and cogent evidence of a diminution of consumer surplus. And you also leave room for possible defenses that these practices indeed do promote, okay, on the whole, advantages for consumers. With an abuse, there is always room for an objective justification. Sure, this practice diminishes consumer surplus to a bit, but there is a good, valid commercial reason beneficial to customers, consumers, for this practice's use. It's always available. Well, almost always available. Okay. Now the benchmark for evaluating abusive practices is the as efficient competitor. Okay? You'll often see this abbreviated as the AEC test. Okay? EU competition law focused, as the Commission focuses it, is not concerned with protecting any competitor, right? You want inefficient competitors to exit the market. Isn't that the whole point of competition law? Right? Is that sort of almost Darwinian, survival of the fittest. Instead of the fittest, it's the survival of the most efficient. Right? Okay. Now, so what the Commission is going to be looking at is not how a certain practice affects not just any competitor, but a competitor that's as efficient as the dominant undertaking. Okay? If an as efficient competitor to the dominant undertaking is eliminated or can be eliminated from the market by that dominant undertaking's practices, then that conduct is typically abusive. I say typically because there may be a commercial defense, but it's typically abusive.
So if that practice would essentially kick the as efficient player out of the market,
It's
then it would be
abuse.
considered an abuse.
Yep, prima facie abusive in the absence of some sort of commercial, bona fide commercial justification. Okay, so that's the benchmark. The AEC test, yes.
How could you define the competitor as efficient?
You gotta look at the books, basically. So even though they didn't want to look at the books, now you have to look at the books, okay? But you will see that there are some practices, okay, particularly when we get to rebates and discounting, that you don't even need to take a close look at the books. You look at the cost structures. Okay, so bear with me for about another week, okay? It will become slightly clearer, okay? Okay. You need to take in a relative quantitative or qualitative evidence. Okay, now, this guidance paper, couple of things, okay? Couple of things here. First of all, as we said, it's a guidance. This and other similar documents are binding on the Commission. They're not binding on the court. They're also not binding on member state national authorities. Okay? It sets out the Commission's priorities. Okay? And just because the Commission has not prioritized the practice doesn't mean that it's going to ignore the practice. Okay? Or doesn't mean the practice is legal. So the Commission will still occasionally come after cases where there have been exploitative abuses. Okay, there's a really cool one in Lithuania, or was it Latvia, which we'll get to, an exploitative abuse. Okay, now the AEC tests, okay, requires a careful and costly analysis to determine the existence and scope of competitive harms, and it seems to therefore diverge from an object analysis in 101. In 101, okay, and it's more closer to an effects-based approach of 101.1. Okay. Now the court seems to agree with the Commission's approach to look at, to use the AEC as the benchmark. So in the Intel case, okay, this involved discounting and rebates in microprocessors, which we'll get to next week. Okay, indicated that the benchmark here was the as efficient competitor. And again, the court recognized it requires significant analysis. Now the problem was in Intel is that the court, this was an appeal to the ECJ, the court below it, the general court didn't engage in that sort of analysis. So it got kicked back to the lower court to re-engage with the analysis. Okay. So the Intel case is going to be dragging on forever and a day as a result. Okay. And then you need to look at, for instance, in this analysis, the capacity to foreclose or exclude competitors may be objectively justified. Okay, so there's your objective justification. Determine whether the exclusionary effect can be counterbalanced or outweighed by efficiencies generated for the consumer. So there's your objective justification. So look, what Intel is saying is that yes, the AEC benchmark is at least a, if not the, appropriate benchmark, but it requires a significant amount of data, an analysis of the data, to look at the various cost structures. It also requires a significant amount of evaluation of the foreclosure effects, the anti-competitive effects, against any potential benefits to consumers. Okay? And you need to balance these favorable and unfavorable effects. Okay? So this requires expensive economic evidence to illuminate and to prove the harm. Okay? And of course, the conclusion is only as good as the evidence, or at least how a judge treats the evidence. Okay. We're going to stop here for today, and I'll wrap up a bit of the dominance, and then next at the beginning of Monday's lecture, and then next week we'll go through a number of specific instances of harms to exclusionary harms to competition abuses. Okay.
how fast I'm walking. About 25 minutes. It takes you about 25 minutes.
I went for the bus this morning for 15 minutes.
Yeah, no, that's why I stopped waiting for the bus. Because by the time the bus arrived, I could walk. Crazy.
Still working on it, like, probably could be more than an hour.
I've literally not done